Very warm good evening to all. Today we are going to discuss one more judgment which actually affects our daily life. Now, when we say daily life, it means saying it is useful even to the common person. Now, to common person, we say that how can a judgment be useful to common? It can be useful to all because the reason behind that, the judgment pronounced by the Supreme Court, it affects the complete country. In fact, even to the foreigners. Now, this is a judgment of the Arnesh Kumar versus State of Bihar. Few of you may be aware about the same. I'll share the judgment also. This is Supreme Court judgment of 2014. It is a bench of Chandramouli, Kumar Prasad and Pinaki Chandra Ghosh. Now, this judgment, if you see, it is pronounced by Supreme Court and it is about the arrest guidelines in the country. Now, the common thing we face every day as a lawyer also or as a personal individual also, that police comes to you and you do not know about your rights. If you read this judgment, I bet on you that you will know what are your rights and also you can defend your client better. Now, Arnesh Kumar versus State of Bihar is not something which is saying something new, but because it was pronounced by Supreme Court, it is actually having lot of, I would say, authority. And in this judgment, if the police do not follow the guidelines given in this judgment for the arrest of any individual accused, then there is a possibility also, there is a, I would say, observation made by the court that you can also file a contempt petition against the police officer. So how powerful is this judgment? Now, what is this judgment about? This judgment says if a person has committed an offense and which is punishable up to 7 years, the police officer need not arrest the accused individual or the person. It may be a woman, it may be a man, it may be an old man, it may be anybody. Even for foreigners, this applies. So if a person is arrested in a cases where there is a punishment up to 7 years, then you can apply this judgment. Normally, all the police officers across the country now knows this judgment, so no arrests are made. Now let's see the history behind this judgment. This is a case where under 490A, an FIR was lodged against the in-laws and the husband. This husband, Arnesh Kumar, knocked the door of the trial court, that is session court, for anticipatory bail. It was rejected. He went to High Court. It was rejected. After rejection from the High Court, he went to the Supreme Court. And when this matter came before the Supreme Court found out that this is a matter of 498A and also a Dowry Prohibition Act, where some dowry was demanded. Now, when you read this judgment, the court has made an observation. The judges have made an observation that 498 matters. This arrest is used as a humiliation or sometimes as a tool for getting more alimony. This may not be true in a general way, but sometimes it is used by some women or some ladies for getting more alimony, or there are some cases where false imprisonment is done or false cases are lodged. Now, in this case, when you see, if you read this judgment, there was a demand of dowry and there was also a harassment. But the court came on all the observation, and not only for 498 matters. There is some assumption, wrong assumption, I would say, that they feel that this applies only to 498 matters. No, this judgment applies to any offense where the charges under IPC, the punishment is given up to 7 years. So any offense, not only 492, any offense where the punishment is up to 7 years. So whenever a client comes to you, you have to check the charges leveled against your client in the FIR by the police. If the charges are up, which is maybe bailable, maybe non-bailable. See, for bailable offenses, you get a bail as a way of right. But there are some charges which are bailable. There are charges which are non-bailable. If both these charges are there in the FIR, and if you see the punishment is only up to 7 years, you can take the umbrella or the you can take the, I would say, help of this judgment and get your client to go for anticipatory bail. Also, this judgment speaks about that whenever a police officer comes across a case where the punishment is up to 7 years, he has to call or give a notice of appearance. That is section 41A, capital A. That is called notice of appearance. I will also share this notice also. Just a minute. Note 40, section 41A, notice of appearance before police officer. The police officer shall, in all cases where the arrest of a person is not required under the provisions of subsection 1 of section 41. So you have to read section 41 as well. Issue a notice directing the person against whom a reasonable complaint has been made or credible information has been received or reasonable suspicion exists that he has committed a cognizable offense to appear before him or at such other place as may be specified in the notice. The police officer, those who are practicing lawyer, they may be aware that is under section 41A, your client may have received a notice. So whenever a client calls you and he say कि मुझे पुलिस के call आया है, मुझे जाने में डर लगता है, ask him simple question, do you know the charges? If you don't know the charges, you can call the police officer, and as a lawyer you are entitled to know what are the charges level against your client. And if you know this charges comes under the bracket of up to 7 years, you can always tell the police whether you have issued a notice under section 41A. Now this is a notice of appearance. The client can go on his own. He can take help of you, that you can be present with him. But always remember, if the client do not follow the notice given under 41A, the police officer from the permission by the from the magistrate can always arrest your client, even if the charges are up to punishment for 7 years. So always remember, the Arnesh Kumar case supports you only if you follow the procedure which is given in the CRPC, Criminal Procedure Code. So CRPC is a very important part, and section 41, section 41A, I would say complete section 41 and 41A you should read only for the purpose what are the arrest guidelines and this judgment Arnesh Kumar versus State of Bihar. The reason behind this judgment, as I have said in the beginning, that arrest brings a lot of humiliation. Also, sometimes the FIR is used as a tool to score the personal score. There may be partnership business where the people are saying that there is a cheating, but another partner said there is no cheating. Now, this is a dispute which is of a civil nature. There may be element of civil and criminal in any of the cases, but that you can only apply in anticipatory and tell the court and convince the court and go for quashing before the High Court under 482 CRPC. Also, this one more thing which I'm repeating, if the police do not follow Arnesh Kumar guidelines for arresting the accused while arresting accused, then you can always file a contempt petition before the Honorable High Court of the respective state. If you're in Delhi, before Delhi High Court. If you're in Mumbai, before the Bombay High Court, Aurangabad bench, or Goa bench, or Nagpur, wherever you are, wherever the police station comes in the jurisdiction. So read this judgment if possible, and anybody who is practicing civil, criminal side, or any lawyer, consumer lawyer, if you may be practicing the High Court or Supreme Court, but this judgment is one judgment. As a lawyer, as an individual of the country, you should know, because it does not only help the local people, the citizens of our country, but also to the foreigners. So this is a judgment which is a milestone judgment from the Supreme Court. Everybody should be aware about the same. Now next we go to the reading a judgment again on 498 by Tanya. Tanya, you can unmute yourself, please.
Am I audible to everyone?
You are audible.
Very warm good evening to everyone. Should I start the reading?
Just a minute. This is a judgment from the Punjab and Haryana High Court, a very basic judgment, but a lot of things will get clear. And why we should read judgment, I will be telling you at the end of this reading of this judgment. ताने आप यहाँ से start कर सकते हो. The petitioner is facing.
Just a second. Okay. The petitioner is facing trial in a case FIR number 240 dated 20th June 2005, registered at PS Sector 17, Chandigarh under Section 498A, 506, 406 of IPC and Section 4 Dowry Prohibition Act. The instant petition has been preferred under Section 482 of CRPC, read with Article 2 to 7 of the Constitution of India for quashing. FIR number 240 dated on 26/2005 registered at PS 17 Chandigarh. Charge sheet at annexation P13 served on 30th
April 2008.
30th April 2008. Order of JMIC Chandigarh, AS Shergill Annexation P12 dated 30th April 2008 to the extent it is not discharging petitioner of charges under 498A and 506 of IPC. And SK Agarwal's ADJ Chandigarh order dated 23rd and 23/7/2008 and 13/1/2009, dismissing respectively petitioner's criminal revision number 85 dated 25/5/2008 and revision application dated 23/8/2008. The petitioner has been charged for offense under section 498A and 506 of IPC, wide charge sheet dated 30th April 2008. On the allegation that he subjected his wife Jaspreet Kaur to cruelty after February 2004 and that he threatened her on 17/3/2005 with an injury to her person, the petitioner had filed an application for discharge under 227 of CRPC, which was dismissed by the Judicial Magistrate First Class wide order dated 30th April 2008 by a detailed speaking order running into 11 typed pages. The revision petition filed against the order dated 30th April was dismissed by the learned additional session judge, Chandigarh, wide order dated 23/7/2008. Subsequently, the petitioner moved another application, raising 22 points, which have been left undealt, wide order dated 23/7/2008. The said application was also dismissed, wide order dated 13/1/2009, on the ground that in view of the earlier order passed, it was not feasible to review order dated on 23/7/2008. As such, the application was held non-maintainable. Mr. G.L. Sadana, learned counsel for the petitioner, has challenged the charge sheet order of the learned judicial magistrate first class, Shri A.S. Shergill, dated 30th April 2008, and the order passed by the learned additional session judge, Chandigarh, dated 23/7/2008 and 13th January 2009, respectively, contending that the following points should have been decided by the court below. Should I read this also, the FIR?
No, you can escape. No, you can escape.
Okay. Why these admissions be not presumed under article or under section 294 of CRPC, especially when para 41 of the lower court's order mentions that the law on which defense counsel relies has not been disputed. Number 4, most crucial legal completely demand of money for domestic points to be applied ignored by ADJ household expense or due to while involving any financial stringency does not section 498A come under the purview ambit light of Supreme Court ruling of section 498A. Same allegation, similar judicial notice of ignored complaints filed by the same court's judgment complaint against the same were required to accused already decided by taken so as to Mohali, Kararar court preempt the 4 charges. When the charge for demand of crucial legal point ignored, dowry under section 4 of the dowry as per the wording of Prohibition Act has been section 498A itself brought against the petitioner, then how can the same facts be used to frame him under section 498A ab initio within the wording? For example, in the said section, when the demand for dowry be presumed, it was certainly not unlawful. This does not fall under the explanation whether reliance on and the critical legal issue ignored binding on the apex court ruling, and this honorable court allied court's decision duly brought to the court's notice involves any cross-examination. Was prima facie precedent 6 thereto was not mandatory? Allegation under 498A, not critical legal issue ignored, believed in respect of love marriages, Punjab and Haryana High Court judgment. It was mandatory for lower critical legal issue ignored court to state the basic grounds which compelled him to charge the petitioner under 498A and 506 of CRPC. How could order of district critical legal issue ignored guardian judge dated 2/6/2005 and 11/6/2005 and session judge's order dated 8 December 2006 of the Chandigarh District Court be ignored for charge under 506. How does charges under 506 be critical legal issue ignored levied without even an iota of inquiry to the complaint, as the prerequisite is threat with injury and to omit to do what the complainant was legally entitled to do? Her title whatsoever had been ruled out by DGJ's order dated 2nd and 11th April 2005, when at the time of the bail, both critical law point ignored. The complaint and the APP limit the scope of FIR and suggest that the main real issue relates to extramarital relationship of the accused, then how he is being charged under 498A and 506 of CRPC. Do the police have the license to critical legal issue ignored conceal some relevant and critical documents and information pertaining to the case just to frame someone? How the requirement of section 277, critical legal issue ignored, and 293 of CRPC have been fulfilled when the submission of the petitioner have not been decided or considered. When the basic complaint dated critical legal issue ignored 15/6/2005 is admitted not on record, then how can the FIR 14 sustain? When the complaint dated critical legal issue ignored 21/4/2005, which forms basis of bail proceedings both at the district court level and even in the high court is dropped, then why double jeopardy and under 14 which law? Statement under 161 of CPC, do critical legal issue ignored not lend any precedence to any complaint or charges? They have no evidentiary value and are neither prima facie basis for charging an individual. Complaint's own petition critical legal issue ignored dated 26 April 2005 for restitution of conjugal rights condones all allegations of cruelty, leaving no basis for charges in question. No FIR legally permissible on critical legal issue ignored second complaint, then how come an FIR dated 26/2005 could be possible? Item 4 in this list dated 12/7/2008. The first ad was made to Mohali critical legal issue except for a police on 23/2005 who did not slight reference find it fit for registration of case. Issue of then, how come Chandigarh jurisdiction was police could entertain a third left untouched, complain and register a case thereby exceeding their 19 jurisdiction. The order does not have any critical legal issue ignored reflection of a reasoned order as per the legal requirements. Chandigarh police committed a critical legal issue ignored contempt of court by entertaining a matter which was sub judice and also in civil court in Mohali and Kharar. How could a statement under 161 critical legal issue ignored having of Shri I.D. Karla, not even signed by 10, form a prima facie evidence for framing of charges? Item 3, 22 pages, 16. I have heard learned counsel for the petitioner at length and carefully considered every point raised before the revisional court and before this court, but I am of the view that the grievances of the petitioner is that from the inception till the framing of charges, the entire proceedings are vitiated. The investigation is biased and that the continuation of the proceedings against the petitioner is an abuse of the process of the court. It is pertinent to observe here that at the time of framing of charges, the trial court is required to determine prima facie whether any offense is made out on the basis of report under 173 of CRPC after taking into consideration all documents and statements appended thereto. The probability of the allegation being false and the material being weak is not within the ambit of the jurisdiction of the court framing charges to be considered at the time of framing of charges. If there is any defect in the investigation or there is any malified attribute to the investigating agency, it is always a good and sufficient ground to seek acquittal in the adversary system of criminal trial prevalent in our system for administration of justice. It is always for the prosecution to discharge the onus of proving the charges against the accused beyond the shadow of doubt. The process of cross-examination provided under the law gives a fair opportunity to the accused to falsely the witness and to elicit truth to enable the court to separate chaff of falsehood from the grains of truth. An opportunity is granted to the accused to produce defense. The Constitution provides right to every citizen to seek expeditious trial. I have considered all the pleas raised by the petitioners. All the pleas constitute probable defense available to the petitioner, which are required to be put to the investigating agency as well as the prosecution witness, including the complaint. After the dismissal of the revision petition against charges, the scope of interference in the exercise of inherent jurisdiction is very meager. Power under 482 CRPC can be exercised only if there is an established abuse of the process of the court or exercise of power is necessary in the interest of justice. The petitioner will have enough opportunity to impeach the credibility of the witness cited in the case put forth by the prosecution and seek acquittal. It will not be prudent at this stage to quash the charges. I have gone through the order passed by the Judicial Magistrate First Class dated 30th April 2008 and Revisional Court 23/7/2008 and 13 January 2009 respectively, but do not find any ground to interfere in the order of framing of charges against the petitioner. The petition is dismissed. However, it is observed that any observation made by this court or the court below at the time of dismissal of the application for discharge filed by the petitioner will not in any manner affect the merits of the case.
Thank you, Tanya. Very nice.
Thank you.
Now, if you see this judgment, there were so many sections mentioned in this judgment. And in this judgment, when you see that a petition is made before the High Court, again a matter of 490, as I said. Now, it was meant for quashing. The accused wanted to quash the FIR and the charge sheet, and they did try the discharge application after framing of charges. They also tried to revise that order which went against them for discharge application. Thereafter, they went to the High Court for quashing. Now, when you read this judgment, you come across so many. There's a IPC section. There's 498/506. So when I say try to read the judgment, I say that you get to know the sections again. Also, there is a 227 CRPC that is for discharge. There is a revision application made. There is also a section 294 CRPC where documents are given. What are the evidence against in the charge sheet against the accused. Now, though this was dismissed, we get to know so many things from the judgment. So it is one good judgment which you should know, and it mainly discusses the power of the High Court under section 482 CRPC. What are the inherent powers? Now, normally, even as a lawyers, we feel 482 is only for quashing. No, under 482, you can go for any order to be modified or any relief to be asked from the High Court. Under 482, the High Court has got an inherent power. So 482 is very exhaustive. It is not only for quashing. We normally use it for quashing the charges under CRPC. I remember I've used this 482 CRPC when one of my lady client was given a heavy bail of 50,000. And so she was asked to bring solvent surety with Tehsildar certificate. Now she was unable to bring the Tehsildar certificate because she was not having any property in the district of Mumbai. So we went to under 482 asking that amount may be reduced. And the High Court was kind enough to reduce it. So 482 CRPC can be used other purposes than quashing also. So the power, if you read 482 CRPC, go and today, and you will find that it is about the inherent powers of the High Court. So it has got the High Court got an ample power. Now next we will be going through some words, that is legal vocabulary. Now I would like to tell all of you that here that it's not that only as a lawyer, when we go to the court, we can speak simple English. That is the best thing we can do. We can speak also in the local language when we go to the local courts, and judges also appreciate. But there is a possibility, our country, like every 10 kilometers, I would say the dialect, the language changes. Even if you take Marathi language, the Marathi language spoken in Mumbai is different. If you go to Palghar, it is different. If you go to further Amravati, if you go to further Nagpur, the language is little bit different. So always there will be changes in the wordings and language. So English is the common language we are using. For High Court and Supreme Court, this language is mainly used. Some of the lawyers try to speak in Hindi, and the court also allows, but there is a possibility that judges maybe, if a South Indian judge who doesn't understand Marathi or Hindi, there is no meaning. Now, when we say language, तो सारा खेल language का है. The way you speak is also going to reflect how much you know and how humble you are and the way you are putting up your case. Now, normally when we say oblige, sir, the meaning of it is I am grateful to the court. We don't say thank you, sir. If we say thank you, sir, the other lawyers आपको पीछे से बोलेंगे thank you नहीं बोलना है कोर्ट में. I am grateful, sir. I am obliged, sir. Obliged, sir. I am grateful to sir. I appreciate the time given to me for hearing to the court. We say like that. Now here, or say my pleasure to appear before the court. Now in this section of the today's session, I will be reading some words. These words are a little bit difficult, but we can try. Now we said the learned judge has passed a wrong order. Now the word wrong is very difficult. You can use the word the learned judge has erred, ERRED. So these are the words we can use, and these words will come in your language, in your drafting, only when you keep on reading. I've taken out few words. I'll try to see that we can use all these words. Just a minute. Let me share. Finding some difficult in sharing. Can you see the screen? This is the first
Yes,
word
ma'am.
is ventured. You can see the screen?
Yes.
Yes, ma'am.
Okay, okay. The first word is ventured. Now ventured, see this word is used in some of the judgments. Before venturing into anything, I would like to hear the complete plan and strategies to understand the intricacies of the trial. Before venturing into anything, आप किसी भी इसमें venture करना मतलब कुछ साहस करना है, कुछ नया चीज करना. I would like to hear the complete plan and strategy to understand the intricacies of trial. Trial का क्या intricacies है, छोटी छोटी चीजें क्या है. The next word is locus. Locus is a very famous word in the case. आपका locus क्या है, आपकी स्थिति क्या है इस केस में. The intervener has no locus to intervene the matter, as the question of granting or refusing bail is in the court's discretion, or you can use the word court's domain. See how we can use the word locus. When sometimes when I'm standing in the court for my client, somebody comes and they intervene in my matter. So I will say, what is the locus he has got? उनका क्या काम है इधर? Classicus. The observation made by the judge in the judgment have become locus classicus. Now meaning of the classicus is exemplary representation. कभी कभी कोई जज कोई चीज ऐसे ऑब्जर्व कर देते, वो बता देते. So this is the locus classicus, the observation made by the judge in the judgment have become. This word is little difficult also and heavy, but you can use as you grow in the practice. Now next word is unwittingly. Everybody knows the meaning of unwittingly. The allegations in the argument were unwittingly made in the flow before the court, and the same should not be taken as offense. Sometime when we argue in the court, so this is a sentence by one lawyer in the court, which I found in one of the judgment. कि उन्होंने बोलते बोलते कुछ बोल दिया ऐसे, but he said it was made in the flow of the argument before the court, and same should not be taken as offense. कभी कभी जो lawyers होते हैं बोलते बोलते कोई word चला जाता है, by slip of tongue भी बोल सकते हैं इसको. Unwittingly made in the flow before the court, and the same should not be taken as offense. कभी कभी opponent जो lawyer होते हैं उसको learned friend बोलते हैं, उनके बारे में भी कभी कुछ बोलो. We couldn't say that you should not take offense. It was only for the matter I have spoken. Warding off. The girl tried to ward off the blows of an unknown person with the belt of the purse. Now this is a sentence where in the criminal matter it was used कि वो लड़की पर कोई अटैक कर रहा था अननोन पर्सन, तो उसके पर्स से बेल्ट से वो वार्ड ऑफ कर रही थी. लैंग्वेज इज वेरी इंपॉर्टेंट. Delineate. The program was delineated in such a way that everyone could speak and make their point. जो प्रोग्राम था वो इस तरह से बनाया गया था कि everyone could speak and delineate word you will find में describe भी आप इसको बोल सकते हैं. It was delineated, it was meant that way. Deliberately. Deliberate is a regular word used in the legal language. The petitioner deliberately remained absent to avoid to follow the court orders. हम कह सकते हैं कि petitioner को deliberately जानबूझकर वो नहीं आते कोर्ट में, to avoid to follow the court orders. Erred, as I used in the beginning, the trial judge erred in appreciating the evidence in favor of the defendant. Now this was a civil matter where the trial judge or the civil court judge, he erred in appreciating जो evidence उनको सामने है उन्होंने, he erred, he made a mistake in not recognizing the intricacies of the evidence which was produced before him or her in favor of the defendant. Propounded. Now propounded का मतलब है कि प्रतिपादित करना, ये जोर से बोलना या उस बात को स्थापित करना. The theory propounded would not help if you are not consistent with your work. This is a general sentence made, but propounded का भी word काफी use होता है legal judgments में. Adumbrated, and this is a very difficult word. I did not find it is copied from the one of the judgment only. The legal position adumbrated hitherto, we are prima facie of the opinion that the trademark Whirlpool has acquired reputation and goodwill in this country, and the same has become associated in the minds of public or potential buyers with the goods of the first respondent. Now Whirlpool, everybody know it's a brand, so this was some copyright matter था. So the legal position adumbrated hitherto we are prima facie. So legal position जो बताई गई है. So these are few of the words we are should learn, and these are only 10 words. You can find many words and you can make your diary or a notebook, or you can also in the word file and revise these words. Every day if we use 5 new words for the legal, I would say, not the English language, the words which are required to be used in the court. If you use these regular words in the court, the judges get impressed, the opponent lawyer also get impressed. Now sometimes we say there is no embargo, there is no restriction. Restriction word बहुत simple है, आप बोल सकते हैं कि embargo नहीं है, so there is no embargo, ऐसे कोई रोक नहीं लगी हुई है. So these are few words you should use whichever court you are. It may be high court, it may be supreme court, it may be trial court. But if you use good language which is of from the legal background, it reflects that your study is good, your representation good, your understanding of the case is good, and you are working hard on your matter. So this helps everybody. So try to read the judgments and take out 5 words each day if you can, is possible. Even if you take 5 words each day, it will be 150 words at the end of the month. So this was all about today.